Further hearing in the appeal, Four Seasons Holding Incorporated against Brownlie.
You were on your feet?
Yes. Milady, overnight we've had a letter.
Yes.
Conscious of the time limits that I have and the fact that this might take a little bit of time. The letter, I hope I don't sound like a serial complainer, has a number of problems about it.
Sorry.
Well, first of all, it's unattested. We don't really know what her authority is. And in particular, we don't know the extent of her knowledge of the particular arrangements with the Four Seasons Cairo Hotel. The question that's been answered here is, with respect, not the question that the court posed. The question the court posed was which company managed or operated the Four Seasons Hotel in Cairo.
Why isn't that question answered in the final paragraph?
My Lord, because that itself is unclear, in that it would appear that there would be some sort of agreement that was in existence. Is there agreement? We haven't seen it. We don't know what it says. And more particularly, what we don't know, my Lord, is what the arrangements were up the line, which would indicate how it was that that particular LLC came to be empowered to use the tree logo of Four Seasons.
Well, I mean, there must have been a licensing agreement.
Well, there is, and we haven't seen that, so we don't know how that operates. We don't know whether there was a management agreement either, because that's not referred to.
Well, it is in fact referred to, because what is said is that the hotel was operated through the agency of FS Cairo Nile Plaza, acting for and on behalf of Nova Park. Now, I suppose it's possible that there might not be a formal agreement, though it seems most unlikely, but whether there's a formal agreement or not, that is an assertion that there is a contract of agency between them, whether formal or informal.
Yes, but what it doesn't answer is any of the agency agreements that might exist up the line, my Lord, which would lead us back to Holdings, which, as we know, is the entity which appears, around which is focused the tree logo, the device, which we find on the brochure. My Lords, the problem with all this is that it's not addressing the question which needs to be addressed in this case. In our respectful submission, this is a principal and agency issue. It's not piercing the corporate veil or anything like that. It is a brochure which they choose to put into the domain of the public, in particular to guests who are staying at the Four Seasons hotels. That brochure gives no indication of which entity it is that is issuing that brochure to its guests. All that it has on it is the tree logo. So on the face of it, that is, and giving its environment in which it is given to guests, namely in a Four Seasons hotel with all the branding that goes with Four Seasons and all the names that it calls itself. The brochure also has on the back of it Four Seasons Hotel.
But I mean, why are you going on about the brochure? This contract was made with the concierge at the Cairo Hotel.
Yes, my Lord.
The question is, who was the concierge working for? Now, this letter does answer that question. It says that the hotel was operated by FS Cairo Nile Plaza on behalf of Nova Park. So what you are being told there is that persons working at the hotel, like the concierge, were actually working for FS Nile FS Cairo Nile Plaza LLC, acting for and on behalf of Nova Park. Now, neither of those entities is the person whom you have sued.
No, but the person we have sued, my lord, is the entity that was operating or organising the tour. And that's what our pleading
But
says.
that is what your pleading says.
Yes, my lord.
But the problem is, if you stick woodenly to that particular doctrine and evidence is given at the trial that makes good these assertions, your client will fail.
My lord, my client won't fail because I have the opportunity.
Apart from the misnomer point,
Which I am happy
we
to.
needn't debate any further, but cannot be regarded as certain, to put it mildly.
Well, my lord, with all these, and that was the point of taking the court respectfully to the case of Wong to indicate that, and the case of Moran, was because it indicates that the principal and agency concept which runs through all these tour excursion cases is that if you have a public face, which if you present yourself to the public without defining, that was the point of Wong, without defining who it is that you're dealing with or the terms upon which you're going to deal, well, then you will be taken to be the entity that you appear to be for the purposes of the contract.
Forgive me, Mr. Ross, that wasn't what Wong was about. Wong was a case of the tour operator was perfectly clearly identified, and there wasn't any doubt about it. The only question was whether they could say it wasn't us, it was we were acting for a principal. And the answer is, if you appear to be contracting as principal and someone behind you is undisclosed,
Yes.
you remain liable.
Yes.
That's how I understand the law.
But, my lord,
But that's fine and dandy if your target is clearly identified, as they were in Wong and Mrs. Justice Davis's case. Your problem, as I understand it, is that the target is not clearly identified. You're going to be asking the court in due course to infer or conclude that the person that Lady Brownlie was dealing with was the first defendant. And the problem is, as I understand it, that there's at least a serious risk, if what's in this letter turns out to be true and accurate and proved, that she wasn't.
that she wasn't, forgive me.
She wasn't dealing with the first defendant. The plaintiff in Wong was dealing with the tour operator.
My lord, that is right. On the facts of that case, it's one stage removed from this. But
Okay.
the principle is exactly the same in our respectful
Okay.
submission,
All right.
which is that if you are presenting yourself to the public, then the fact that you may have some internal arrangements which you don't disclose to the consumer, then you have no grounds for complaining because
Okay.
you are putting yourself forward as the principal to
Yes,
the contract.
If you are, and if it's known who is doing the presenting to the public, the problem in your case is that it isn't clear who was doing the presenting to the public.
The only way in which you can, well, my lord,
It would become clear if these facts were proved. It would become clear if these facts were proved that the concierge was an employee of FS
yes,
Cairo Nile Plaza, acting on behalf of Nova Park.
yes.
Now, that would identify the person who was dealing with your client.
At all events, now that you've got it, the real question is, what do you want to do?
Well, my lord, we're in an impossible position with respect, and this is something that we didn't ask for. And indeed, it's something which arose before Mr. Justice Tugendhat, and this was trailed in front of him. And he
It's
said,
very
I've got to deal with
unfortunate
this
this was
on the
made.
basis of the evidence before the court, my lord.
It's very unfortunate that this disclosure, which you have a strong case for saying ought to have been made at the outset, should only have been made now. But that's what's happened. And the question now arises, are you proposing to ignore this and simply proceed on the speculative basis that you may be able to establish liability against the first defendant, or do you propose to do something just in case this statement, which on the face of it has been responsibly and carefully prepared, turns out to be true?
Well, my lord, there are a number of stages. First of all, we need to know what the full position is. It's not appropriate to ask us and our client to deal with this. She's not in fact available.
What you're being asked to do
Yes.
is to answer the question, do you propose to do anything just in case this turns out to be right? I quite see that...
My lord, if you're asking me that hypothetical, yes, the answer would be that we'd apply to substitute. That is, that we'd say this is a mistake, and we'd invite the court's attention to the cases in the White Book on that.
Yes, well, that application would presumably be made to the High Court. You would need to apply to add parties. You would need to apply to serve the writ out of time against the second defendant.
Well, my lord,
You might need to apply to extend the limitation period.
No, well, my lord, no, because could I invite the court's attention very briefly to the White Book in this connection? I think the passages have been handed up to the court. The White Book's not available.
I've received some
You've received some cases.
but not an extract from the White Book. Unless
No, we've received quite a lot of cases, but
Not
Well, the relevant bit that you want may be cited in one or other of these.
Yes, well, it's CPR 19.5,
Try inside.
1.3.
No.
do we find this in one of these cases?
I'm sure we will, my lord.
Paragraph 23 in the inside.
Yeah.
yes.
So the additional substitute of a party is necessary only if the court is satisfied, A, that the new party is to be substituted for a party who was named in the claim form in mistake for the new party. Then the RSC notes are at 19.5.2 for your ladyship's
Sorry, in what document? I don't think we've got those, have we?
19.5.7 in particular, where these cases are referred to. Would it be helpful if I just very briefly,
Do we have a copy of that document?
for some reason you haven't, my lord? It's not helpful.
Well, it's quite difficult to follow these technical matters simply on that.
That's why.
You're in an extremely difficult position. We have put you in that difficult position.
Could say that, my lady, yes.
Well, I've said it. It is the case. Anybody who was watching yesterday's proceedings would have realised that we have put you in this difficult position, which you rightly foresaw when you somewhat objected to our putting pressure on the defendant to be more forthcoming. The question for us now is what to do next. Were you to wish for there to be an adjournment of these proceedings so that you could take instructions and work out a variety of possible courses of action, both for you and for us? Because obviously one of the things that we could do is send the case back to the High Court for a proper issue to be tried about who is or are, there might be more than one, proper defendants to this claim, and for you to make whatever applications are consequential, in a sense, on what the outcome of that would be. That's one thing that we might consider doing. And we might consider doing that irrespective of how we then resolved the other issues in the case. Equally, we might continue with the hearing and try and resolve the other issues in the case, leaving that possibility open.
Well, certainly we need an opportunity to reflect on the contents of the letter and to ask what I would still call interrogatories, would be requests for further information, to get to the bottom of the uncertainties that are redolent in this.
And you also want proper evidence, don't you?
And proper evidence, and it needs to be attested and matters of that sort, because it's one thing to be told what the corporate structure is. It's another thing to be told what the interrelationship between the companies is on the management side of things, because you have evidence from Mr. Newman that this is a management company, the defendant that we've selected. But what is it that it's managing? It sounds as
The
if...
second defendant, this is. You mean the second defendant?
I mean, Four Seasons Holdings.
No, the first defendant.
Yeah, I see.
You mean the first defendant?
Well,
Yes,
That's the one that,
Yes,
of which Mr. Newman says it's a management company.
says it's a management company.
Yeah.
I really don't want to add to your difficulties, Mr. Ross. That's usually a precursor to doing so, but am I right in thinking that since we are talking about potential liability in contract, on the identity of the defendant may depend the choice of law? If Mr. Justice Tugendhat is right, I imagine he is on this, pick it up in paragraphs 90 and 91 of his judgment. Choice of law in contract depends first of all on anything that the contract says. It's Rome 1. Depends first of all on anything that the contract says. If the contract doesn't say anything, which this one on the face of it probably doesn't, yes?
Probably doesn't, my lord, yes.
Then it's the, in a contract for the provision of services, the contract is governed by the law of the country where the service provider has its habitual residence. Now, that would mean, I speculate, I'm not asking for a response, Mr. Ross, you must think about this, but it might mean that on the identity of the defendant means whether the law to be applied in due course of the trial, even if there is substitution, is Canadian or Egyptian. So it may matter quite a lot.
Mr. Ross, of course, in a sense, this question of the proper identity of the defendant comes first, because all the other issues that you've raised offer an acceptance, the difficulty about the tort claims, all or part or none. It's all that's got to be argued out between you and the proper defendant at some stage. And so until that's sorted, there's an argument for saying, what's the point actually in our addressing those issues?
Well, my lord, in the short time that we've had available, our reaction to this was that there should be an adjournment so that we can contemplate our position and for the defendant to put forward whatever evidence it wants to put forward in a form which is acceptable. Because the alternative is I proceed inviting this court to deal with the issues on the evidence as it was presented to Master Cook and to Mr. Justice Tugendhat and say this is all too late, it's got nothing to do with anything at all. But we're in the real world, and I anticipate that it's going to be extremely difficult, even for a tribunal as august as this, to expunge from its mind entirely that which is now being placed before
Well,
it.
it may not be in your client's interest that we should do so. That's the problem.
Yes, that's right.
You need to, what matters to you is that you have at some stage, in the end, an identified defendant,
Yes.
preferably insured, but if not,
That's what-
against whom you can launch your claim.
which we don't know. Yes, yes. The point being, I digress only very briefly to say this, because I'm clarifying a point your lordship raised, my lord, Lord Hughes raised with me yesterday. Company search in Egypt did not reveal who owned and who operated this hotel.
No, it may well not do.
And similarly, the searches in Canada, the court may be surprised to hear, are remarkably uninformative about what you can discern. You simply get information that there are Four Seasons companies. That's it. Nothing underlying it. So the whole of the interrelationship between Four Seasons entities and the hotels that are put out to the public as being Four Seasons hotels is a complete miasma.
Well, that would be equally true wherever they were incorporated. If they...
That may be so, but it is it is something that's not even in the public domain. I mean, you won't be surprised to hear we've searched internet, etc., to see if we can get to the bottom of it. There is complete opaqueness on this issue. And so, coming back to where we are, we would like to have the opportunity to reflect on the position, for the defendant to decide how it wants to present any additional evidence to this court, for us to have the opportunity to ask any further follow-up questions which need to be asked because it's not providing the answers that are material to this court's consideration of the issue that's before it, and also on the question of substituting a party. And for us to have the opportunity to reflect on the substitution of the party on the basis it's a misnomer, because these authorities, if I try and encapsulate them, indicate that if you, as I was seeking to suggest to the court yesterday, I'm gratified to know that my recollection was correct, if you identify in your pleading, as we have done, the owner, operator, or organizer of the hotel, in particular the excursion, engaged in the sale of this excursion, then that identifies sufficiently for the court's purposes the entity that you're intending to sue. The fact that you call it ABC Limited when it's actually XYZ Limited is a classic case for misnomer. That's what we say is the case here. We've identified on this hypothesis, they would say we have wrongly identified Holdings as being the entity that was operating the hotel. If we can now ascertain which entity it was that was operating the hotel, that's a fortiori case for a substitution on the basis you've wrongly described, as opposed to wrongly identified the party you're intending to sue.
So you're asking for us to adjourn the case?
Reluctantly.
I know, reluctantly. And there may be certain fairly obvious cost implications, bearing in mind who's responsible for this situation.
Indeed, milady.
So perhaps...
And indeed, going back to the pre-action letter we wrote, which the court will be fully aware of.
Well, perhaps we better hear from Mr. Palmer before we...
Could I just say this? I mean, presumably there are a whole series of possibilities. One is that it would be very risky to choose just one of these defendants.
My lord, yes.
And, for example, if you see the hotel was operated through the agency of FS Cairo, acting for and on behalf of Nova Park. Now, how does the law of undisclosed principles apply in this kind of situation, in circumstances where nothing was disclosed to begin with?
Other than the logo and the name.
Other than the logo, yeah. So it's tricky.
Yes.
And it may look
It's
very
tricky,
good.
but not necessarily insoluble.
No, that's right.
May, for all you know, get an admission eventually.
Well, perhaps we better hear what Mr. Palmer has to say about your proposal.
Well, milady, the position that we have found ourselves in is one in which we started off before the master. We put in what was adequate evidence if it was interpreted in a sort of common sense and robust way that FSHI Limited had no agreement with the hotel and was not responsible for the hotel, and that there were other companies within the group, and therefore relied upon the doctrine of separate corporate entities. Now, I accept that the defendant who was sued did not, as it were, assist the claimant by identifying a specific party that should be sued, but they did identify the hotel. That led the claimant to sue the hotel, which is Nova Park Cairo Company, SAE, and they then unaccountably did not pursue those proceedings. Had they done so, and had they obtained permission to serve that company out of the jurisdiction, we say they would have had a perfectly good and adequate remedy.
But the question for us is that we have an application to adjourn this hearing consequent upon the bombshell which you launched yesterday, admittedly at our prompting.
Yes, I was just wondering who
And
pressed that particular trigger.
all we are interested in is your answer to that application. I'm not sure that anything that you have said is actually an answer to that application.
You don't think there is anything I can say?
Very well, Mr. Palmer, we better...
Forgive me, you've misheard.
Yes,
I think the lady said that she didn't think that thus far you had provided an
I
answer.
see, sorry.
Yeah, I didn't say there wasn't an answer. How could I know what your ingenuity might produce?
Your lady, I thought your ladyship thought there wasn't an answer. It is a matter, perhaps, of tactic and the sensible way forward for my clients. They have invested a large sum of money in bringing these principles, these questions of law to the court. And I'm not quite sure whether your ladyship is suggesting that everything that has happened, as it were, thus far would be thrown away, or whether your ladyship is suggesting that there be a relatively short hiatus in which the contractual and corporate position can be clarified to the satisfaction of either the claimant or the court, which can, of course, be done under, we would ask for, if it is to be done, that it be done under a form of order of disclosure of information, because there is power to make that order, and that would that the exercise of that power would certainly allay any fears that my client has about the commercial confidentiality of the organisation of their corporate group.
There are some issues, are there not, which are raised by this appeal, which it would be appropriate for us to consider, or might be appropriate for us to consider, whatever may be the instructions that may be obtained from Lady Brownlie about your recent letter. In the first place, there is a potential question about what is the test, or at least how you apply it, of good arguable case in this kind of case. Secondly, there is a question about how you identify the location of the contract, which at the moment falls to be decided on evidence as between the first defendant and the claimant, but might, if other parties are brought in, have to be decided as between the claimant and other parties who possibly are more likely to be liable. There is an issue as to the proper law, which may affect the application of the Fatal Accidents Act, and there is an issue about the gateway relating to the location of damage in tort. Now, all of those questions they're questions on which the Court of Appeal has pronounced, and on which it may well be appropriate for us to say whether we think that they were right, irrespective of what happens about the issue relating to the correct defendant to sue. I put that forward as a possibility worthy of consideration by both of you.
Well, that's why I started with the question of where the contract was made, because that had nothing to do with the identity of the correct defendant. It just had to do with evidence from the concierge, which is unobtainable, and Lady Brownlie, which is before the court. And so that has nothing to do with the identity of the defendant. And if we're right about that, and the Court of Appeal and Mr. Justice Tugendhat was wrong, then there is no contractual claim, full stop.
Well, no, that's not right, because if the correct defendant is the second defendant or the Nile subsidiary of the Four Seasons Group, then they will not be bound by any finding of fact that the judge or the master or indeed ourselves may make. And if the matter went back to the High Court for an issue to be determined as regards the application of the liability or potential liability of other parties, then they would have an opportunity to produce evidence, if they have any, to clarify the issues which we have struggled with in the absence of any direct evidence. There would be no point in our deciding it simply as between parties who may not be the right parties.
Well, I'm not sure whether...
Indeed, you say are not the right parties.
Incidentally, I'm not making any suggestions. I'm asking what the various... We've had an application for an adjournment, which I took to be an application for an immediate adjournment, so that we do not continue with the rest of the hearing until Mr. Ross has had the opportunity of reflecting and also consulting his client, because of the importance of the development. Even though there are issues which don't depend upon this and which we could and probably should resolve, nevertheless, there is a necessity for reflection, and one of the issues, at least, as my lord has pointed out, may crucially depend upon who is the appropriate defendant. So I'm not...
A logic suggests that we should adjourn all this now. We should have any question which arises out of this determined under some suitable order by a first instance judge, and then we can take it from there. Because otherwise we shall have a lot of confusion as to what the position is along the lines that my Lord Sumption indicated. So that if we then discovered what the position was from then on, we could then consider in what circumstances, if any, to resume the appeal. That would at least have the advantage of taking it in coherent steps, whereas if we decide all these matters now, in the absence of people who are going to be parties the day after tomorrow, the situation may prove to be more confused than it is at the moment. Anyway, that's just a thought.
Well, I mean, I accept that if my learned friend wants to proceed against Nova Park Cairo SAE, then he obviously has a...
Possibly FS Cairo Nile Plaza LLC.
That is obviously a possibility that he would want to join that Egyptian company.
No, that isn't the... Is that an Egyptian company?
It's an Egyptian limited liability company, yes. So it's a... In my respectful submission, this court should determine the issue of...
That's an Egyptian company owned by the
Four Seasons.
three internal Four Seasons companies.
Yes.
It's owned in one-third shares by...
FS is, but Nova Park, by the look of it, isn't.
I'm sorry.
FS is, according
Yeah,
to your...
Nova Park...
It's quite separate.
Nova Park is a completely separate company.
And Nova Park is the one which is at least arguably the current second...
I think almost...
Previous second defendant.
I think almost certainly, but we couldn't quite identify why there was that slight difference in nomenclature. But an SAE is a...
Well, that does look like a real misnomer.
Yes.
Yes, that is a misnomer. I would accept that that was a misnomer if it turned out it is called Cairo Company. What I would submit is that we have a case here in which my learned friend has sued the holding company. The holding company has said, we are not the party you should be suing. And I accept we now have the difficulty that we have put in a letter setting out in more detail what, as it were, the positive position is rather than merely the negative position. But there is, I would respectfully
They
say,
haven't entirely come clean as to who they should sue.
we haven't.
No.
Well, my Lord, I have always said they should sue the hotel, whose business it was, and whether FS Cairo Nile Plaza LLC were running the hotel as agent for the hotel, the concierge is binding the hotel, Nova Park Cairo SAE, through the agency.
What your letter says. Your letter says, effectively, that the right party to sue is Nova Park, and that the entity which no doubt employed the concierge was only doing so as agent for Nova Park. That may or may not be right, but that's, I think, fairly clearly what you've said in your letter.
Well, it depends entirely on what sort of agency it was. And of course, on any view, it was for an undisclosed principal. So,
well, they were both acting for undisclosed principles, I suppose. The concierge and the and FS Cairo Nile Plaza LLC were actually entering into a contract.
well, Mr. Palmer, I think you're maybe in danger of repeating yourself if you
Yes.
say this. And I must ask Mr. Ross what his instructions now are having.
Mr. Palmer, do I understand, just before you sit down, what you're at least asking us is to consider not abandoning the hearing, but simply adjourning it?
At the very least, it should be put back to enable my learned friend to take steps and, if necessary, to have an issue determined.
We're not proposing to, as I understood it, it was simply an adjournment of this hearing that was applied for. I wasn't making any proposals. I certainly wasn't proposing that we would abandon it.
The only thing
Might in due course, but I think...
The only thing I would say in response to my Lord's assumption is that if my learned friend decides to pursue other entities besides or instead of Four Seasons Holdings, Inc., nevertheless, in my submission, the issue as to where the contract was made can be decided in the proceedings as presently constituted.
But only as between some parties.
I accept only between those parties, but given that I don't understand why my learned friend's advisors did not pursue Nova Park Cairo SAE at the same time as pursuing my client. They just abandoned in the 3 months between issue and applying for permission to serve out. They simply abandoned the claim against the hotel. And I simply don't understand why that was.
But that's not going to help us decide what to do this morning, is it?
No, it isn't. But my submission is that the court should decide that issue as between my client and the claimant on the evidence which has been presented in the case. And then my friend can go away, and if he wants to seek to issue separate proceedings against other defendants, he can do so. And that would be a better course to decide what can be decided now, and then to leave the hearing, as it were, incomplete on the question of Four Seasons liability because it was a contracting party to the contract.
Location of the contract, which is the issue that you're saying you would like us to decide
Yes.
or resolve, is relevant only to the application to serve out. It isn't a trial issue at all.
Quite. And albeit...
So it's got nothing to do with anything if you cease to be the relevant defendant.
But equally, it is open to be decided differently in a case which may be brought against or continued against FS Cairo. And I submit that is not a particularly undesirable outcome, although there may be inconsistent findings. The principle is that on interlocutory hearings, you have the material you do on the interlocutory hearing. You're not making an issue estoppel decision which binds people who aren't yet parties. So I would submit that my Lord Sumption's approach up to that point was correct, that the question of where the damage was sustained, question of liability for fatal accidents, liability in tort, and the question whether there is any case against my client in contract because the contract wasn't made in this country, can all be decided. And the only thing that needs to be put back is the question of whether my client should be in the action at all, and whether it was a contracting party. Now, it may be that I can persuade my friend by, he can be persuaded if an order for disclosure of documents is made, that there is no arguable case against Four Seasons Holdings Inc. I think that's so. I'm content for an adjournment to be granted for that purpose, but I would ask that the hearing continue for the purpose of deciding the issues which are live and fully developed and unconnected to that particular issue.
You mean this morning?
Yes, albeit that my friend might have to be given a little more time.
Well, he can't be given any more time.
No.
There is no more time. We have to finish at 1 o'clock.
Well, that's what I asked for. He'll have to squeeze his submissions
Thank you,
in.
Mr. Parker.
He doesn't have to deal with the submissions about the contractual identity now.
I still ask for my adjournment.
You'd like us to adjourn now?
Yes,
Yeah.
yes.
And not continue the hearing yet?
Not to continue the hearing yet until we've had an opportunity to reflect on that which has been tossed our way overnight.
Well, we will rise for a moment to decide. We have decided to grant your application, Mr. Ross, for an adjournment of the hearing today. We are, of course, not abandoning these proceedings in this court. There are several issues of law which can be resolved independently of identifying the proper defendants to the action, and we would therefore propose to resume the hearing as soon as possible in order to resolve those important points of law. So we shall be looking for a date, as I say, as soon as possible, before the long vacation, if at all possible. In the meantime, of course, you will be wanting to reflect upon the position, and you will be wanting to achieve proper evidence and proper disclosure in relation to the contents of the letter, and we would propose to make an order to that effect, but we will invite counsel to propose the full form of order that we should make after such reflection and such negotiation as you are able to engage in, rather than now trying to do it off the top of our heads. Well, yes, that would be part of the evidence that ought to be. The letter ought to be verified, as I said, by proper evidence.
By proper officer.
And that would include, and attached to that would be proper documentation to support it, and indeed anything else. And also, you may wish to ask questions as a result of that disclosure. And so that possibility has to be incorporated in the order. We are, of course, mindful of the expense to which parties have been put by this very late emergence of this information, and we will in due course bear that in mind when we come to consider what the cost implications of this development are. Does, I think, resolve everything so far that we've decided?
Yes.
Regrettably, it's not possible for this court to continue with the hearing this afternoon, and so we do have to adjourn it today.
Had to have been very short.
Well, it was partly with that consideration, Mr. Ross, that we thought it right to adjourn the proceedings. Had it been possible to carry on this afternoon, that might have been a little bit more difficult to decide, but it not being possible, we have to allow you at least the full amount of time to address the other issues.
So, my lady, the intention is that council should together draw up a form of order which we can present to the court for the court's
Yes.
approval.
Yes, yes. And we would hope that you
Do
would
that
be
as
able
soon
to...
as we can, but
yes.
it's a flexible timescale.
Yes, well, in the meantime, we will be looking for... we'll be looking for a date. I would suggest that you do it within 7 days. If you find 7 days impossible, well, let us know.
For preparing an order.
Yes.
Oh, yes, no,
I would have said within 7 days.
yes,
No.
yes, certainly.
It seems a reasonable time, doesn't
Yes,
it?
indeed,
Yes.
lady.
In the meantime, we will be looking to try and find a day before the long vacation on which we can resume this hearing. This may not be altogether simple, because obviously the Constitution has to remain the same.
Indeed.
But we will do our best.
My lady, may I just raise one matter, which is the issue of whether some other party is to be somehow joined into this issue, because my Lord Sumption's problem was that a determination of where the contract was made in the context of this appeal would not bind anybody else.
What I said carefully was that we would seek to resolve the issues of law arising on this appeal.
Yes, I see.
Should the claimant decide to seek to sue other persons or join other persons or change the identity of the parties currently before the court, well then it may very well be appropriate to send an issue, which is basically an issue depending upon evidence, back to be resolved at first instance. I'm not saying that that is.
But that won't upset the if we can find a date before the...
It's very important, as far as we're concerned, that any future proceedings proceed on the proper legal basis.
Yes.
The remaining points. Very well. The court is reluctantly now adjourned.